This is a standard agreement that you didn't draft. And there are a number of things which are in this agreement. At 5.1, for example, it says the landlord holds the deposit as security for compliance by the tenant with the terms of this agreement. If the tenant fails to comply and as a result of the landlord suffers loss, the landlord may take an amount which is not to exceed the loss from the deposit. It goes on, the whole of that section, to talk about the deposit. Where on this lease agreement do I find you deciding or agreeing to waive the deposit? Where do I find that on this agreement?
Because it doesn't state there was a deposit paid.
No. Here, this is the legal basis on which I come to a determination. It makes reference to a deposit, and it talks about the terms of the deposit and her duties and responsibilities in respect of the flat to keep it in good upkeep, etc. And at the end of it, it sets out what happens to the deposit. That implies to a judge, a third party, looking at what happened between the two of you, that a deposit was paid, unless someone specifically writes on that agreement that there was no deposit, your right to take a deposit had been waived. Where do I find on this agreement your right to a deposit having been waived, please?
Judge, you're quite correct. It's a standard short-hold tenancy agreement. Now, when I phoned up the agents on Monday morning to obviously state to them what had happened over the weekend with Judy, I said, I have taken off a 2 months' rent, up front, no deposit.
And they...
So therefore...
Fine. I believe you. I believe even if that happened.
Hence, I haven't signed it, have I?
You mean you haven't signed this agreement?
It was signed on my behalf, by the agent.
Signed on your behalf. You gave them the right to rent the property. They had the conversation. Well, let me ask you, did they say to you, just so you know, we're not taking a deposit or something of that sort? Was that ever said to you?
No, Judge, no.